evening and welcome to the Board of Selectmen meeting for Wednesday, September 12th, 2018. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Tonight we're here to learn about marijuana regulations. This is a question and answer session. All debates should be held to our next town meeting, which is in November. So I'm going to turn the floor over to Lauren Goldberg, our lawyer from KP. She has a short slideshow. Then after that, we'll have plenty of time to answer all your questions.
Okay, good evening, everyone. I'm glad to be here tonight to talk to you a little bit about the new, or not so new anymore, marijuana law. This is a law that was proposed by initiative, and so what that means is it wasn't vetted by the legislature before it was enacted. It was enacted by the people originally through the initiative process at the November 2016 election, and then it was shortly thereafter revised by the legislature to make some changes that they believed were necessary for implementation. One of the sections that it did not make significant changes to was the local control section. And if you had asked a municipal attorney before that, what are the changes that they should make before implementation, it was changes to the local control section. So we at the firm have been kind of navigating this issue with our clients, and for those of you who don't know, the firm represents over 120 cities and towns in Massachusetts. So we've had many opportunities to look at the ways that municipalities are regulating marijuana, help draft some of the original bylaws, and have been providing advice on an ongoing basis. So what I'm going to do tonight is talk a little bit about how we got to where we are, and then about the different options that there are for regulating marijuana under the law, and I can answer your questions. And certainly, if you have something as a burning question while I'm talking, if you want to just raise your hand, and I'm happy to answer it if I can, and if I think it's better addressed later on, then I'll push you towards waiting to see if we get your question answered. Now, I have to do a little bit of the on and off here, so excuse me for that. Okay, so the first thing we're going to talk about is what a marijuana establishment is. What a marijuana establishment is.
Lauren,
so, yes.
Sorry to interrupt you. Will we make a copy of this available to people so
Absolutely.
they don't have to feverishly take notes?
Yeah, I should have said, I emailed this late in the day today. We're constantly updating. We have kind of a version of this that has been available over time, so some of you may have seen it, but we're constantly updating it to address changes in the law, and this is an area where the law really does change on a daily basis. So I did get this to Derek late in the afternoon today. I will, you're welcome to post it or do whatever you'd like with it, and certainly, it'll be available so you don't have to take feverish notes.
Sandra tells me we're going to post it on the website, so it'll be on the town website if you want access to it.
Also, for those of you that don't know, I was just telling Derek earlier, because the 3rd Congressional District is having a recount, and I'm kind of in charge of the elections practice, so I've been trying to make sure that this was ready and also get everybody prepped for that, so that's another reason why it was late in the day today, so I apologize for that. Okay, so what is a marijuana establishment? I think it's important to know what we're talking about, and those terms are defined in General Laws Chapter 94G. And that is a marijuana cultivator, a marijuana retailer, a marijuana product manufacturer, an independent testing laboratory, and any other type of licensed marijuana-related business. Now, what are other types of licensed adult-use marijuana establishments? And I want to remind you there's a difference, and we'll talk about this in a minute, between medical marijuana establishments and what they are just calling marijuana establishments, or licensed marijuana establishments. So the other types of licensed marijuana establishments are craft marijuana cultivator cooperatives, micro-businesses, and marijuana transporters. Not a medical marijuana treatment center, which is an MMTC is what they're called now. They used to be called medical marijuana dispensaries, MMDs. So if you are hearing those terms used interchangeably, that's because under the old law they're called one thing, and under the new law they're called something else. If you'll note from this slide on the left-hand side, it references some regulations. So any holes in the law are essentially filled by the Cannabis Control Commission, or the CCC, through the issuance, promulgation of these regulations. There was a requirement that they be promulgated, I believe it was January 1, and I think they came out with them a little bit earlier than that last year. They did take some comments, but not a ton. A lot of the regulations really look like like the specifications section of a contract. What is allowed, the way cars need to be marked, the way that security protocols need to be filed. So they don't look a lot like what we're used to with laws, but that's what they're doing. They're providing all sorts of limitations on the way these entities will operate. So what is a medical marijuana treatment center? Well, that's something that is licensed right now by the Department of Public Health, okay? So anything that you've read about medical marijuana dispensaries has nothing to do with retail marijuana or recreational marijuana. It only has to do with this medical marijuana. And the Department of Public Health had, as you might imagine, different standards for approving these entities than might the Cannabis Control Commission in looking at retail establishments. So they're two entirely different statutory schemes right now today. At the end of this year, responsibility for medical marijuana is also going to be transferred to the Cannabis Control Commission. So we don't really know what that's going to look like. I think if anyone's been reading the news, you have noticed that the Cannabis Control Commission is in the news all the time. They have a lot of responsibility. I think they have their hands full. I don't think they're quite ready to either promulgate draft regulations or really to kind of give us information about the way that medical marijuana is going to be regulated after December 31st. But for today, we have this, the draft regulations, and we're going to have to see what happens with that. So the Cannabis Control Commission on or before December 31 is going to take over both. Okay, so...
Should
yeah.
somebody flip the slides for you?
Oh, I forgot. Sorry. I can do it. So that's other types. I just forgot all about it. Licensed medical marijuana use. So this is what we were just talking about. Right now known as RMDs and going to be known as MMTCs. I will tell you, I don't know if you read about this, that the towns of Northborough and Bellingham had approved a ban on medical marijuana establishments at their town meetings. So an all-out ban. And the Attorney General approved that within the 90 days that they're allowed by law. And then after that 90 days had expired, they issued a clarification to their earlier approval, which said that they believed that it was actually premature for them to have approved those, that they had made an error. Because the law right now still requires there be a medical marijuana facility in every county. And so if they allowed one municipality to ban, then others could do so, and then no one would be able to have medical marijuana facilities. Medical marijuana is relevant to our discussion of non-medical marijuana, recreational marijuana, because there's certain protections in the law for established medical marijuana dispensaries. And also, if you allow MMDs or RMTCs, as they are now, then you have to allow the same number of marijuana establishments under the law. So it matters if a municipality has approved medical marijuana treatment centers or is willing to approve them. And that is why in Bellingham and Northborough, they wanted to ban them because they didn't want there to be any issue with a medical marijuana treatment center opening in their towns, which would then pose some imposition on their regulation of non-medical marijuana. Make sense? Yes?
Question. So approving, does that mean that the town has actually approved a site, or does that mean that we haven't banned medical marijuana? Because we haven't banned it, we haven't regulated it at all.
So when I'm talking about approval of medical marijuana treatment centers by the town, I'm talking about approval of a bylaw, okay? Most zoning bylaws, and I believe the zoning bylaw here, are prohibitory in nature, meaning what they say is anything that's not specifically authorized is prohibited. There is always an argument, and especially with recreational marijuana, that an underlying use that's the same type of use. So let's talk about a medical marijuana treatment center. You could argue, oh, well, that's the same thing as CVS. I'm not saying it is. I'm not saying that we would agree that it is. I'm just saying that's the argument. Or a retail marijuana store would be the same as any retail store. I'm not saying it is, but you could make that argument. So if you don't have a bylaw that specifically prohibits marijuana establishments or medical marijuana treatment centers, you look to the underlying zoning to see how it would be regulated in most cases. There's also language that prohibits a municipality from making it, I forget what the word is, I know it's in the slideshow, but prohibitively impractical to open. So if, for example, there's one lot in the entire town where you could open a medical marijuana treatment facility or a recreational marijuana facility, but that lot isn't zoned appropriately, or it's subject to a very stringent site plan review or special permit process, one could argue that it's been made impracticable. Okay, so for now, until we hear where the CCC winds up on medical marijuana treatment centers, we're in a little bit of a hybrid kind of waiting period on what the AG will allow and not allow, okay, for regulation of medical marijuana treatment centers. All right, so what is the town's role with respect to adult use marijuana? So adult use marijuana, recreational marijuana, non-medical marijuana, they're all the same thing, okay? And each town can choose how it wants to reference it in its regulations if it wants to. You'll hear all of these terms used interchangeably in the news if you're hearing about this. So under the regulations that the Cannabis Control Commission has adopted, applicants are required to do three things. They're required to have a meeting here in town where they essentially, it's supposed to be a community outreach hearing, where they explain what they're trying to accomplish and how and why, and people have an opportunity to ask questions. And they need to do that at least 6 months ahead. They also have a requirement to enter into a host community agreement with the municipality. Now, a host community agreement, the law does not regulate what the content of that agreement is. It says that there needs to be one, and it says that there can't be a community benefit fee in excess of 3% of the retail value of marijuana, number one, and two, that that it has to be the town's actual costs of regulating the marijuana facility. Okay. Other than that, it doesn't say. It doesn't say what one community might want compared to another community. A community might want a school resource officer, or a community might need additional shifts at night because of where a particular location is, a particular establishment is located. Or there might be a belief that it's imperative that there be community resources for persons with addiction problems or something. So a municipality is supposed to try to analyze the impacts of having a non-medical marijuana establishment in its town, and then try to quantify what the value of that is going to be. Okay. The other thing that the host community agreement provision provides is that the fee can only be in place for 5 years. Okay. Now, some of the ways that the Cannabis Control Commission, the CCC, interprets the law, and the way that legal counsel might interpret the law, can be different. Okay. You might see this with respect to when a municipality is sued and it goes to court and it argues, no, we did everything the right way. We argue a particular action was consistent with law and appropriate, and someone else might argue that it's not. So the way that we view the law is that the fee will be in place for 5 years and it can be renegotiated at that time. I don't know that that's the way the CCC will ultimately rule on that, but that's our perspective right now. And the reason being is that what we anticipate our costs might be today may be very different in 5 years. We're not sure because no one in Massachusetts has had to implement this law, so we really don't know. So the Board of Selectmen and the town manager would negotiate the host community agreement, and they also have to certify compliance with local zoning, including buffer zone requirements, which we'll talk about in a second. So as part of this license application process, the applicant has to say, we've held this meeting, and I'll go to the next one, which is at least 6 months before we're going to file our application. We've negotiated a host community agreement with the town, and there isn't a zoning bylaw that prohibits us from operating in the location we want the license for. Okay? So the way that a zoning bylaw works, in general, is that it's effective as of the date that town meeting votes. So a while back, the AG was saying, if you're looking to prohibit retail marijuana, you need to have that in place before licenses are filed if you really want to protect yourself. And in any event, before an application is filed. And in any event, before they have to certify that they're in compliance. Because if town meeting hadn't voted to reduce or ban by that date, they would say, we have the right to locate here. The underlying zoning is appropriate, okay? So that's what they're having to do. Before they do this community outreach hearing, they have to advertise at least 7 calendar days beforehand. They have to file the notice with the city or town clerk and the planning board, the contracting authority, here board of selectmen and town manager, the local licensing authority, if that's applicable. And we'll talk about licensing afterward. The content of the hearing notice and of the hearing, they have to discuss the type of marijuana establishment. We already talked about there's several different types, so they have to say what type they're proposing. They have to kind of summarize what their security plan will be. They're unlikely to give us the exact details of their security plan, mostly because of trade secret issues. And even though we would have the ability potentially to withhold that under the public records law, it's a lot of responsibility to have that. But we need to understand what their general security plan is going to be. And that would include, if, for example, in North Andover, there was a discussion about building a 1 million square foot grow facility. It has to be inside. And one of their security plans was to do a building within a building. So they were going to have a reinforced, special building within a secure building. And that was one of their security plans. And then they were going to have floodlighting to a certain level, etc. But again, we wouldn't expect that they would say how many times they're going to have security guards walk around the perimeter or that kind of thing, because that would then expose their plan and allow someone to avoid compliance with it. They're going to talk about, one of the things that they're required to do is talk about the steps that they would take to prevent diversion to minors. That obviously is a big concern in every community. They're also going to talk about planning for a positive community impact and information to demonstrate that the location will not be a nuisance. The term nuisance is a legal term that really has meaning that's more significant than just saying something's a nuisance. It has to essentially interfere with the neighbor's right and enjoyment of their space. So for example, in a residential neighborhood, people would have an easier time proving a nuisance than they would in an industrial zone. Because in an industrial zone, you expect that people are going to be making noise and there's going to be lights, etc., whereas in a residential zone, you might not. Okay? So the nuisance factor. Another thing that these facilities, whether they're retail or grow facilities or manufacturing facilities, is the potential for odor. Like most retail establishments, maybe for restaurants we're worried about odor, but most, a store that sells baseball cards, we're not concerned that there's going to be an odor emitting from the store or that the packaging is going to be so attractive to minors that they're going to come in off the street to see if they can buy them. So that's the kind of thing you can expect there to be conversations about. The packaging is something that's regulated by state law, just so that you know, but it's still, I expect, something that'll be discussed at these community meetings. Okay, so that's the community outreach meeting. The next thing that they're required to do is talk about is to enter into a host community agreement. There's been a lot of press about this issue. Some of it, from my perspective, is just flat out incorrect. It's been suggested that municipalities have been interfering with the ability of marijuana establishments from opening. And in fact, that's just not the case. Even those municipalities that have been requesting benefits in addition to the 3% or separate from the 3% have been essentially suggesting those as a request. So let's just say they are able to demonstrate that they anticipate there'll be 3% of the total value of the gross proceeds that they can demonstrate, the municipality can demonstrate will impact the municipality in order to absorb the regulation of this new entity. Maybe there's building inspector fees, maybe there's fire inspector fees, there's ongoing safety inspections, there's, as we said, this potential need for education of minors, whatever it is, we demonstrate 3%, but we also want something else, and we want it for a longer time. So for example, maybe we want a school resource officer, because we have real concerns that, North Andover, this is one of the things that they talked about, if they have the state's largest growth facility, wasn't it possible that the children in the town would need to understand this is a business, It's, you know, like any other business, we're regulating it like a business. It's not encouraging minors to smoke marijuana or to whatever it is they're doing with it. You know, just like alcohol factories, you know, it doesn't mean that we're supportive of underage drinking, that kind of thing. So, you know, municipalities have been requesting this other type of benefit that's not time limited. And some of the developers of these retail establishments and marijuana establishments have been offering things. You know, we'd like for you to have money towards a fire truck because we know that our facility is a growth facility, and if there's a fire, we want to handle it X, Y, or Z way. Or we know that there's going to be a need for extra patrol, so we'd like to donate a police car. So there's those kinds of things in these host community agreements as well. But the idea of the 3% fee is this reasonable relation to actual costs. And as I said, I think it's difficult at this stage to know exactly what those costs are going to be. So there will be an ability to look at that several years down the line. The Act, yeah, as I said, it doesn't preclude renegotiation of the impact fee, although some suggest that it's not allowed. The municipality will be required to document its costs, and the applicant has to certify to the CCC that it's entered into this host community agreement when it submits its license application. Because it's a requirement of the law, there's been a suggestion as well that the CCC should be reviewing and approving these host community agreements. There's, as you might imagine, huge disagreement amongst the industry, which says, yeah, have the CCC approve the agreements, and municipalities who say, there's nothing in the law that says what needs to be in there. Why should they get to approve them? We can make whatever deal we want. One of the reasons that the CCC has indicated is that one of the purposes of this law, as it was approved by the voters, and one of the purpose sections was to essentially avoid continuing to criminalize behavior that they believed should not be criminal. And so the idea being that individuals who are entrepreneurial should have as much of a chance to open a retail marijuana store or a marijuana grow facility as a company that has a ton of money coming from Colorado. And so one of the ways to ensure that, their argument is that if the 3% is the only community benefit that can be provided, everybody has the same shot at getting an HCA or getting a license. I think municipalities have been pretty open that no, they're not requiring any additional type of benefit, but that there's real issues that a municipality is going to have to face that maybe can't be quantified, and that you can't prove is reasonably related to the cost of regulating this new entity. So the short kind of summary on that is I expect we're going to see push and pull with the CCC and perhaps with a lawsuit, and or with a clarification to the law to address just how involved the CCC can be with the host community agreements. Okay, so that takes us up to showing that there's compliance with the zoning bylaw or ordinance, and they have to show that the CCC, that a proposed site is compliant with bylaws or ordinances in effect at the time of the application. So this is my point earlier about having them in place before the application is put in. Once the application is filed with the CCC, it's deemed complete, and they will notify the municipality. The municipality has 60 days from that point to weigh in on whether that location is in fact in compliance with zoning. And if they don't hear from the municipality at all, they're going to presume that it's in compliance. So this can be seen as a burden or a benefit to municipalities, because the burden is we have to respond if we want to make our case that they're not in compliance with zoning, and the benefit is we have an opportunity to say that they're not in compliance with zoning if we believe they're not, okay? Obviously, especially these bigger entities, they have attorneys who analyze the zoning and will make an argument that they're in compliance. So, it is important to pay attention to that date and to calendar it. It's 60 days from the date that they're notified, and that's when the work has to start on that. So what kinds of zoning bylaws or ordinances are allowed? Okay, because that's really kind of one of the major questions. What can we do to regulate? Can we ban? Yes, if we follow certain rules. Can we regulate? Yes, if we follow certain rules. Can we limit? Yes, if we follow certain rules. But we have to follow the rules in order for these limitations to be valid. So here, Derek, I believe, what was it, 52 to 48%? Okay, so it was narrowly approved by a majority of voters turning out in November of 2016. That they approved legalizing recreational marijuana in Massachusetts. The question at that time was not, are you okay with marijuana being sold in your town? Okay? And I don't know if people would have voted the same way if that had been the question. But it wasn't, okay? It was a multi-page law and summarized as, are you in favor of non-medical marijuana, basically. After the law passed, and the general court was trying to make sense of it, and this is what I was saying, you know, they thought they needed to make some improvements, and one of the improvements that they believed they made was to say if your community approved the legalization of non-medical marijuana, then you could only limit the sale in your town under certain conditions. If your town rejected the legalization of medical marijuana, then all you had to do, of non-medical marijuana, all you had to do was adopt a bylaw, and then you could prohibit it, okay? They essentially said, you meant, if you said yes to legalizing marijuana, I'm okay with it in my town, and they meant if you said no, I'm not okay with it in my town, and so that's the concept that they brought forward. And again, we won't know. We don't know what would have happened if the questions were phrased differently at the time that the law was presented. Okay, so what can we do? We can regulate the time, place, and manner of marijuana establishment operations and impose reasonable safeguards.
Flip the slide.
Oh,
All right.
thank you. So that's one thing we can do. What's a reasonable time or regulate a time, place, and manner? We can adopt a bylaw that says where these entities can be. We can, through a licensing process or a bylaw, say when they can operate. And we also can say how they can operate in certain ways. So we have the ability to say, we'll take this kind of marijuana establishment, but we don't want that kind. And the this and that kinds have most typically been recreational marijuana sold at retail in retail stores and all the other kinds. So again, but that's a policy decision, and a municipality that's looking at how to regulate this has to make that policy decision. What's the right policy decision for you? Another thing that can be done is to allow non-medical marijuana in whatever way is the right way, but impose another level of review. Okay, so impose site plan or special permit requirement. So a special permit requirement allows a planning board or the special permit granting authority, it could be someone else as designated in the bylaw, discretion to essentially look at a bunch of different factors and decide. We could say, gee, this doesn't work for us. There's all these reasons why. It's too big, it's too loud, it's too tall, it's too this, it's too that. So we're not going to grant you this special permit to do this thing. Site plan review, there's a little bit less leeway to make discretionary decisions. More if it fits all the categories in there, or if we could put on conditions to make it fit the categories, it has to be approved. Okay? So as a policy matter, you want to leave more discretion to the planning board, you talk about site plan review. You want to leave less discretion to the planning board or the permit granting authority, you do site plan review. Okay? Some municipalities have done nothing. They've just said it's as of right in X, Y, and Z districts. Okay? But others have imposed this site plan review or special permit process. Okay, there's several different ways as well to regulate the uses that we're talking about. One way is to change the underlying zoning. We'll allow retail sales in business district 1, but we're going to prohibit it in every other district in town. Okay? So we can do that, and we can require site plan review, for example, okay, for a retail store. Or maybe what we say is we're going to prohibit retail sales altogether as long as we follow the process, but we want to allow agricultural growing of marijuana in the agricultural district, and we want to allow labs anywhere that medical labs are allowed, and we're fine with cultivators anywhere where there's lots of 5 acres or more, something like that. So we have the choice to treat these different uses differently and to change it in the underlying zoning. So it would go in the use table in the zoning bylaw. The other option is to create an overlay district. And the difference with an overlay district is maybe there's a part here that's residential and a part here that's industrial and a part here that's business and a part here that's, small business zoned or whatever, retail. And we carve out some pieces from all of that, and we think about putting all of these medical marijuana and non-medical marijuana uses in the overlay area. So we've decided this is good, it has access to the highway, this is good, it doesn't go through the middle of town, this is good, the zoning here is large lots only, so if they want to open up a growth facility or whatever, they need to have this much space. And so that's one option. And some towns want to do that because they want to concentrate these non-medical marijuana places in a single area, a geographic area, okay? Others have kind of a dispersion model. They don't want any of these places on top of each other. So rather than put an overlay that's all in one area, they might have an overlay that's kind of designed differently. And that overlay may say you can only have 2, in this area, and you can have 3 in this area, and they each need to be 500 yards apart or something like that. So there's a dispersion model, there's a concentration model, there's an overlay, or there's a change to the underlying zoning, and because I'm a lawyer, you can do some or all of that. So those are all policy decisions, okay? So what are we limited by? Well, we're limited that our zoning bylaws and ordinances may not be unreasonably impracticable. And so the way that this is defined is the measures necessary to comply may not subject the licensees to unreasonable risk or require such a high investment of risk, money, or time that a reasonably prudent business person would not operate a marijuana establishment. This is essentially the reasonable person standard, and it's everywhere in the law. It's really hard to put your finger on it, but in some ways it's of course that's unreasonable. So in my example of only allowing it in one particular place and requiring them to jump through hoop after hoop after hoop, that would probably be unreasonably impracticable, okay? Similarly, this is like a time, place, and manner restriction. No cash may be stored on the premises overnight. Well, how are they going to do that? Who's going to take it with them? Who wants to take a big amount of cash home with them at night? Probably no one. No other business would be subject to that requirement. This one shouldn't either. Okay? So those standards are something that when we look at or we draft zoning bylaws, we're paying attention to that. Okay. So what we had just talked about was a use classification. Marijuana retail is treated as retail, all other retail uses, and allowed to locate where retail uses are permitted, or they're a separate use classification. So that's if you actually put in your zoning bylaw retail marijuana establishment as its own use. So rather than treating it like all other retail establishments, it has its own particular use. So like a hospital or medical office may have its own particular use, even though a general business establishment might have its own line. We can call out the functions that we want to and treat them separately under the zoning bylaw. Okay? All right. So next, we talked about the public nuisance issue. We can prohibit that. Cultivation, processing, and manufacturing. Again, we'd be looking at odor. We'd be looking at release of waste products. We'd be looking at the way that they're managing their business. We can establish restrictions on public signs. So there's already some restrictions on public signs, like you can't use a marijuana leaf, you can't show someone smoking, you can't do several of those things, and that is in the regulations. And as I said, if you remember, the regulations look pretty much unlike other types of laws because they really look like a specifications requirement. If you can check all these boxes, then you've done what you need to. It's like a checklist of standards that you need to meet. They can establish a civil penalty for a violation of a bylaw or ordinance, which we do all the time, non-criminal disposition, allowing us to write tickets for violations of bylaws, or being able to enforce it under the regular statute, Chapter 40, Section 21, relative to enforcement of bylaws. It allows up to $300 for a violation of a bylaw or ordinance, and it's enforced by a criminal complaint filed in court. Okay? What they may not do is bar transportation of marijuana or marijuana products. Anyone think of why that is?
Well, if I have to go to Upton to get to where I'm going to be delivering to, you can't stop me from going through Upton.
That's exactly what it is. It's because it prevents intermunicipal travel.
When I'm transporting.
For transporting, exactly, which is prohibited. Doesn't mean you're allowed to smoke in a car or to use marijuana while driving. I defer to the chief. But it does mean that you can't prohibit people from driving through to deliver marijuana, or essentially from delivering marijuana in your municipality. All right. Is marijuana an agricultural use for purposes of the law? Agricultural uses are allowed by right on lots of 5 acres or more? And the answer is no. It is not an agricultural use for purposes of state law. It is specifically accepted from the definition of agricultural use. So there's no by right ability to open a marijuana facility on a lot of 5 acres or more, okay? Municipalities can regulate commercial marijuana growing. Growing and distribution doesn't count either. So we have that ability. One of the important things in the statute that people are very interested in and concerned about is the proximity of marijuana establishments to schools and to places where children congregate. So what the law says is that there can be no more restrictive imposition than 500 feet. So that's the minimum distance from, and it says right here, from a pre-existing public or private school providing education in kindergarten or any grades 1 through 12, measured from the lot lines. So 500 feet is the maximum distance that can be regulated. So you can't say 700, you can't say 900, you can't say 550, 500 is it. A municipality can allow a smaller buffer zone by bylaw or ordinance. So you could reduce it. And basically this would be more likely in cities where if an entity wanted to locate, it's more likely that there's existing schools nearby. I want to, though, just highlight for you, as it says in the bottom row here, that this buffer is less restrictive than the default buffer under the medical marijuana law. Under the medical marijuana law, what it says is that it shall not be sited within a radius of 500 feet of a school, daycare center, any facility in which children commonly congregate. So there's differences in the law, so differences in bylaws right now. Again, I anticipate that these will be made holistic when the authority to regulate transfers to the CCC. Okay, so there are 3 things that in a municipality that has approved the legalization of marijuana, there's 3 things that you cannot do without both a local ordinance or bylaw and a ballot question, okay? So you can't prohibit the operation of one or more types of marijuana establishments without both a bylaw and a ballot question, okay? Same thing, you can't limit the number of marijuana retailers to fewer than 20% of the number of retail off-premises alcoholic beverages license issued by the municipality. So this is your number of package stores, all right? You can't provide, you can't limit the number of licenses to that less than 20% of your retail package store licenses. So if you just have one retail package store, you got one retail marijuana location, unless you do a ballot question and a bylaw that prohibit that, all right? So, and you round up. So if it was that you have, I'm terrible at math, I'm not gonna tell you, but you round up. So if you have 7, you're really treating it like 8, and then you figure out your 20% there. I could probably try, but I'm not gonna do it. All right, and then the last thing is you can't limit the number of marijuana establishments to fewer than the number of medical marijuana treatment centers that have been registered to engage in the same type of activity in a municipality. So if you already have a medical marijuana treatment facility, you can't limit the number of non-medical marijuana retail any type of establishment to fewer than the number of medical marijuana treatment centers. And that's why having MMTCs or RMDs matters, okay? The other thing is if you had an RMD that was registered or licensed as of July 1, 2017, then that entity could not be prohibited from converting to a recreational marijuana establishment. Okay, but we don't have that issue. So those are the types of things that you can do, but you can only do it by adopting a bylaw or ordinance. And in a municipality like yours that voted yes, you also have to have a ballot question that does the same thing. And it's very strange the way it's written. The ballot question is like, do you approve of a bylaw, of the bylaw below? And then you actually reprint the bylaw. And then there's a summary as well of what the bylaw means, okay? So normally, shall this town vote to, or shall this town, do X, Y, or Z? It's approve a debt exclusion, authorize or weigh in on curbside collection or something like that. And it's a question. You answer yes or no. Here it's, do you approve of this bylaw? And then the entire bylaw is printed on the ballot. And I can assure you that city and town clerks throughout the state are not pleased with that. Zoning bylaws are very long, oftentimes, and the whole thing has to go on the ballot, okay? Now, what happens if I know those of you town meeting people out there are thinking, well, things change when you go to town meeting. You go to town meeting with a bylaw, and it can get amended on the floor of town meeting. That's true. If you voted at the polls on the bylaw before town meeting, and town meeting changes it, you've got to have another ballot question, which is a lot of work, okay? So some moderators have been saying, you can vote to amend this, but if you do, it's a rejection of this bylaw, because it will not take effect. So we don't know how Dave would interpret things, but we could talk to him about it. All right, how do you do this ballot question? Basically, the statute, as I said, presents the form of the question. The town clerk has to get notice at least 35 days prior to the date the question will appear on the ballot, as is the case with any ballot question. And then it goes on the ballot and it's approved up or down, and there's this Milford decision, which stands for the proposition that I'm telling you about. If it's not approved in exactly the same form, it's rejected. So this next slide doesn't apply to you, but I thought it would be important to keep it here so that you understand why other communities may be just approving a zoning bylaw and having it be effective, okay? Or a general bylaw banning non-medical marijuana and having it be effective. It is going to evaporate, that authorization, after December 31, 2019, and then everyone will be subject to the two-step process. Evaporate's a legal term. Okay, at least you guys are awake. All right. So even though the law allows this either to be, the law doesn't really say how to regulate marijuana. What it basically says is you can adopt reasonable time, place, and manner bylaws, but if you want to regulate, to do any of those limits or prohibitions, you do it through a zoning bylaw. We weren't convinced that you couldn't, and we're not convinced that you can't ban the sale of marijuana or marijuana establishments in a town through the adoption of a general bylaw, and several municipalities have done so, okay? But if you want to regulate, if you want to say you can only do it in this area and not in this area, and you want to do an overlay, or you want to impose a special permit process, then you're probably talking about a zoning bylaw. And the AG has encouraged municipalities, even doing a total ban, to go the zoning bylaw route. Again, I think there's a risk with doing the general bylaw, not because I don't think the law allows for that, but because you can never guarantee that a municipality is not going to get sued, as I'm sure you all know, and so it's easier to defend if you have gone the zoning bylaw route based on what the AG has said in her opinions. Okay, so as it says on the slide, the language is ambiguous. The AG has approved both for the prohibition, but to the extent that you're going to be regulating one district over another, that's going to be a zoning enactment. 2/3 vote at town meeting. Okay, so even though the stores aren't able to use a marijuana leaf, apparently we are. Municipalities can impose a bylaw limitation on marijuana retail establishments amounting to, as we said, 20% or higher than the number of package stores issued without the two-step process. So just a single step. If what you say is we have 20, please God, someone help me with this. We have 20 package store licenses, then we can have 4. Is that right? 20%? 4. We can have 4 retail establishments. We can limit it to that. Okay? We can limit the type for each of them to 4, because that's not less than 20%. That's 20%.
Marijuana establishments, not just retail.
Right, marijuana establishments, not just retail. Okay? So that's a single-step process. Conversion, again, I know this doesn't apply here, but I wanted to at least make sure that you had it in the event that you were curious. On-site social consumption. We get a lot of questions about this. The law says that you can have a petition of not fewer than 10% of the number of voters of the town voting at the state election preceding the filing of the petition. File a petition, which would then force the question to go on the ballot at a biennial state election of whether to authorize of social consumption. And social consumption is what I am led to understand is a quote-unquote marijuana cafe. That's what they're called, not marijuana bars. It's marijuana cafe. And that means that people could ingest marijuana together in public, okay? So there's no law right now that allows that. People can only do that in private. They're not allowed to congregate in the open, in public, and ingest marijuana. This provision would appear to authorize that. But how it's to be done, we will wait and see. And the form of the question isn't in the statute, and there's a million other things, and because I'm an election law person, I have a number of recommendations to fix this. We'll see if they do in time for the next state election. I know of no community that's doing that right now. It is not going on the ballot in anyone's municipality on this state election, okay? So we will see. All right, what's another option with respect to marijuana, regulating recreational marijuana, and that's a zoning moratorium, which we're familiar with. It allows a municipality to essentially put like a pin in it for later. And the pin basically says, we're looking at this issue, we're trying to analyze where it should go, we're working hard on coming up with regulations, the law is changing, and so we are not going to make any allowance for this type of entity until pick a time. Now, originally the AG had said December 31, 2018 was the time, but she has since approved some extensions of moratoria through July 1 or June 30, 2019. And so there's case law that suggests that it's okay to have a moratorium as long as you're actually doing the work towards figuring out the issue. If you're just doing it as a way to prevent the use, that's not going to be upheld by a court. So it means you need to undertake an actual planning process if you wind up with a moratorium. Now, a lot of municipalities have been doing a number of these options on the same town meeting warrant, which is really confusing for most people, but they have tried to give as many options as possible. So the first one is allow it as of right in all these districts, and the second one is allow it subject to special permit in X, Y, or Z districts, and the third one is do an overlay, and the fourth one is do an all-out ban, and the fifth one is do a moratorium. And so if you get all the way to the fifth one, you know we can't agree. It's actually a way to demonstrate to the AG or to anyone who's looking to challenge, no, we really can't agree. You know, we had all these on there. Now, sometimes using parliamentary procedure, one of them will be moved up, but the fact that they're presented gives some support for the conclusion that it can't be worked out. Another way to do that, of course, is to take the time to try to come up with a bylaw that works and present that bylaw. If that bylaw doesn't work, so just one bylaw and then a moratorium, and then to adopt if the bylaw doesn't pass. Moratorium is a zoning moratorium. It's a 2/3 vote, just like the law, a law to regulate would be a 2/3 vote. And it is also the case that it is sometimes hard to just get a 2/3 vote on these matters because people feel strongly one way or another. So even if you come into town meeting with the hopes that one of these is going to be adopted, it is possible you only get a majority vote on both. As we talked about, 52 to 48% or something close to that. That is not a 2/3 vote. Okay, so you can see it might be hard to get people to come down on one side or the other in favor or against a particular plan. Okay. There is a local...
Council,
Oh, yes, sir.
Our existing moratorium expires 12/31.
Yes.
Okay, sorry.
Yep. No, I'm aware of that. And so it is before that law, that the way the AG was interpreting the law, you were stuck with that until that was it. You had to have an answer by that date. Because if you didn't, it'd be subject to the underlying zoning. If you do nothing, subject to the underlying zoning. Okay? The AG has allowed extensions of moratoria to June 30th, 2019. But again, it needs to be a demonstration of an actual planning process. Not just, gee, we couldn't figure out what we wanted to do because we never met. Meetings like this, meetings of the planning board, meetings of the board of selectmen, talking about this and dealing with it at the community level, that's a way to demonstrate that the municipality is working towards a plan. And again, it can be hard to get a supermajority. The other thing that is allowed as part of this is if there's going to be the retail sale of marijuana products, then the municipality is allowed to accept a special section of the law that allows the imposition of a local tax, and that is any sale or transfer of marijuana or marijuana products by a marijuana retailer operating within the town up to 3% of the total sales price. So one of the amendments to the law was to increase that amount from 2% to 3%. So the municipality, if you have a retail marijuana option, regulating of retail marijuana, on the warrant, you would also want to include this local option for consideration, or you may want to include it. This is a revenue source for the town. Yes?
Is that in addition to the community agreement?
It is. It is, and it's by statute, and it's also in addition to the state tax. Okay? So this is just another mechanism for the municipality.
But a marijuana establishment can determine what they want to give. That's a retail, that you're talking about, the 3%.
What I'm talking about right now under the local tax option is a statute, which if you accept it, the municipality by law, by act of that acceptance,
Yep.
can impose whatever percentage, from 0 to 3%
Whatever
tax
percentage,
on
right.
top of whatever the state tax is. In addition, there's the host community agreement, where there's a negotiated fee that's supposed to reimburse the municipality for some cognizable impact on its finances. And then there's other municipalities, other entities that have been making what they have termed voluntary donations of other types of benefits that may not be quantifiable in the same way. So those are different sources of potential revenue for the town. Now, in my experience with municipalities, none of these things are revenue generators the way that it's been, I don't know what the word is how do I describe it, the way it's been characterized in the press. There are expenses with any type of new business, with any type of non-regulated business that becomes a regulated business, whether it's a pharmacy, whether it's a compounding pharmacy. We see that. If a new entity comes in that's going to do gravel removal, we're pretty sure there's going to be an impact from that on the town. So this is essentially a codification of the process that's typically entered into with an entity when it comes into town. When you look at doing a TIF agreement, or you look at to do a tax incentive for a company to come into town, you're looking at all the ways that this is going to impact you, and that's part of why you agree to do the TIF agreement. You're bringing them into town, you're hoping for benefits over a particular term. A host community agreement is a way of dealing with that. This tax option is a way of dealing with that. Yes?
I have a question. Here is kind of interesting. It says 3% of the total sales price.
Yes.
Is that equivalent to saying we can tax a business up to 3% of their gross revenue?
Yes.
Okay.
It is in fact an explicit statement. So there's a whole difference in state law between what's a fee and what's a tax. And there's a bunch of case law that explains those. And a fee is something where it's a voluntary service that the entity is getting. So if I want to go into the clerk's office and get a certified copy of my birth certificate, I don't have to get a certified copy of my birth certificate. I'm not required to do that. That's a voluntary choice on my part. So I can pay the fee, which is supposed to reimburse the town for things like the paper, the ink, the time that the clerk is taking, the computers, the lights, the town hall renovation, and all that stuff. You can go into kind of figuring out what's reasonable for that fee. But if that fee was set at $300, and there's no way to differentiate why that amount is at $300, then someone could challenge that and say, no, that's a tax. It's a birth certificate tax. And this is a great example. Under those circumstances, if they went to court, they would say there's this thing called the Emerson test. It has to be reasonably related. It has to be something that's voluntary. And there's a couple other standards. So if the legislature says we can impose a sales tax, they are actually saying, regardless of the impact on the municipality's finances, they are allowed to tax this entity just for operating in the town. Okay, so that's not subject to a challenge. That exists. Yes?
Well, I had a different motivation for the question, which is if we can tax on sales price, then a retailer could say, well, the sales price is half the actual sales price, and they have this fee.
They have to
And we can't
report.
tax the fee.
They're required to report to the licensing authority. So that is the way that that's dealt with. They have to also pay sales tax themselves. And so if they doctor their books in that way, that would be a violation of law. Also, in the host community agreement, there's an opportunity to negotiate over what kind of information you're provided, and that's something that could be requested. You know, we want whatever's filed with the state, and we want every 6 months a report. And I know that municipalities have been asking for documentation.
And it is the only industry that does this. When you buy a six-pack of beer, you don't pay 3% to the town. It is the only industry out there that is paying direct tax to the town, 3% or whatever's negotiated on the community host agreement.
Yes.
Meals tax.
Meals tax.
What difference in meals?
Right,
Meal
there's
tax,
meals-
5%, correct.
Yeah, there's a meals tax and
Thank
there's
you.
also a hotel motel tax. So the
Thank you.
state gets to decide if we're allowed to do that. And the difference between a regular tax, which is general application, a real estate tax, and income tax, is that this is a local option tax. It's up to the municipality to decide. Let's just say we're in a community that sees a huge financial benefit from just having the retail sales. They're not looking to get any tax payment on that. They don't have to adopt this. They can just, just pass it up. They don't have to adopt this. If a municipality is looking for revenue, this is an option for them. Yes?
Just to the gentleman's comment, I don't think it's unique because there's a hotel tax in Boston.
Yes, that was pointed out to me, thank you. And a meals tax, and Uxbridge just passed a meals tax
Yeah.
recently. We never had it before, and so the
Okay.
food goes up a little bit, and when you buy marijuana, it's gonna go up a little bit because you're gonna be paying that tax.
Yeah.
They're not.
The state started with these types of excise taxes over and above regular taxes during, I think it was in 2010 with the, I forget exactly what it was called, but a Municipal Relief Act or something back then. And so that was really as a result of the recession and the difficulty that municipalities were having meeting their service levels. And so they were allowed to take advantage of these additional optional taxes. So
Are those
global
taxes
acceptance.
also capped by the state?
Sorry?
Are those taxes also capped by the state?
It's, yes, 3% is the limit that a municipality may, they can choose. It used to be up to 2%, now it's up to 3%.
No, the question is, are the meals tax and the hotel tax
Yes.
capped by the state?
They are, yep, absolutely. Yep. Okay,